Library. My name is Ken Vercammen. I'm here to kind of answer people's questions on wills, power of attorney, and living will. So when we're on the topic, you can raise your hand like you would if you were in grammar school, and I'll try to touch upon that topic now. So, well, we usually start with, a lot of times people go, well, why do I need to have a will? Doesn't everything go to my spouse and my children? I go, well, yes and no if there's children from a prior relationship, but that's not doing planning. That's just hoping that you won't pass or everything will be good. So the whole idea of having documents is so that there's one less thing you have to deal with. If someone doesn't have a will or it wasn't signed and prepared correctly, state law determines who gets assets. That's correct. But if there's no spouse and 3 kids, that means one of the kids has to kind of say, I'll be the administrator, and everyone else has to agree. Everyone says, oh, my kids will work it out, they're all good. He goes, yeah, of course they're going to say while you're around, no, we're going to work everything out. They're not going to call you up and say, by the way, after you go, I'm going to screw my brother or sister. And and even if they all agree, that means that the other kid's got to sign what's called a renunciation, sign in front of a notary, pay a fee. But that's where they get along. Sometimes you get the one that doesn't live around here, but they're the troublemaker. No, I'm not signing that thing. I want to be in charge. Well, that means that then they got to spend thousands of dollars of going through what's called a formal administration and go in front of a superior court judge, file a complaint, order show cause, and everyone on the planet that would inherit, since there's no will, has to be formally notified. Then there's a hearing. So the whole idea of having a will is why go through this, $4,000 or $5,000 process when typically a $500, $600 will resolve it. Number 2, if there's no will, that means the person who is the administrator has to take out a thing called the surety bond. That's another grand or so. Number 3, there's no will or it's not signed right. State law determines who gets assets, and a lot of times you want to decide too. It's your right to do with your assets what you want. One of my clients said, do I have to treat all my kids equally? I go, no. If you want to give everything to the Yellow Dog Society, that's your right. I go, what's your concern? He goes, well, one of my sons, and he lives on the West Coast, we don't, hear much from him. I goes, well, I'll ask you a couple questions. Did he send you a card or call you on your birthday, Mother's Day, or Christmas? No. Well, why would he give that bum anything? He's a bum. And, in my experience, that bum is going to be the first person saying, the day after you die, where's my money? I haven't got my share. I'd say, anyone can kind of contest a valid will, but it costs money, and the judges are pretty practical. One of our probate judges here in Middlesex, someone was contesting the will because they didn't get what they thought they should have been entitled to, or because they're written out. The judge goes, what proof do you have that of undue influence? Well, I didn't get my share, and then he goes, no, I'm not going to let you go on a fishing expedition. Now, sometimes people call me, oh, I want to challenge the will because I didn't get anything. Okay, I go to the guy, I said, okay, let's say the judge is going to ask you these questions. How many times did you visit your dad in the past 2 years? Well, we had a falling out. Okay. How many times did you call him up or send him a letter or email saying, listen, we both said some things, why don't we go and have a beer or a couple? Well, no, I didn't. I goes, well, what leg do you have to stand on to challenge your will? But so the most important reason for having proper documents is to make it easy for the family and not, not almost cause fights or lawsuits amongst the family. So when people are grieving, you want it to be as easy as possible. So think about, where does your stuff go? And since COVID, things got a lot more, in a way, easier. I mean, the old system would be, okay, husband and wife, either both of you come in and go to our reception area and fill out a form. Pre-COVID, we started emailing it, and then when COVID hit, we didn't really miss much of a beat because we could still email it to them, they could type it up, And because we were closed, they could still go to the UPS store. And he goes, wait, that was kind of an easier way, because then people would say, oh, for signing, what's your weekend hours? He goes, weekend hours? Listen, I'm not coming into the office on weekends. That's my family time. You know, so people can sign in front of the UPS store. So logistically, people are, you know, putter offers. Yeah, I'll get around to it. You know, even people will email them twice. Go, yeah, I haven't gotten to get around to it. And then they say, I'm putting together a list of my assets. I goes, why? I don't need to know your assets. Let's see. New Jersey, believe it or not, did away with the estate cap. It used to be every penny over $675,000 was taxed. New Jersey did away with that. So, and there's no inheritance tax if it's going to spouse, children, grandchildren, stepchildren. There's no taxes going to charities. So, there is a federal tax, though, and it applies to you people in the room that have more than $13,900,000. Who is that much? One time I was at a seminar at Edison Seniors, and I goes, I don't want to insult anyone, but, you know, they're combined. I don't know if we all got $13,900,000. Okay. So that's why I just need to kind of know where you have real estate, because if people have real estate in other states, you know, there's certain things we want to do. But really, you know, we shortened our form. I remember our interview form at one point in time asked all the questions about all of these different, what stocks you have and what this and that. Now, like, what's your name, what's your address, who's executive one, who's executive two, who gets your stuff. Pretty easy. I mean, and then we have a section for questions. But now, okay, the executive. The executive is the one that you know, becomes the captain of the ship. And New Jersey, I'll say it over and over again, is to probate is the estate. You know, as long as you have a proper will done and it's properly signed. So one of the things, though, when I've lectured with the county circuit will say, listen, you people out there, have it done right. They say the problems we have all the time where we got to reject wills is that people try to do stuff themselves and it's not signed right, it's not done right. And the surrogate says, I have no financial interest in this, but this is what we see all the time. And it's kind of like the time I tried to save money by not hiring the electrician and trying to do my own electrical work at my house in Edison. And I goes, oh, I can change the 2 prongs to the 3 prongs. That's easy. And then I almost burned the house down. So, now, sometimes the seniors say, oh, I'm not good with computers, or I don't got email. I goes, hey, no problem. Listen, you got a child or a grandkid that is good with them. They can help you out, and I just need to talk to people. Because sometimes, you know, it's like there's an expression like, you know, you can bring the horse to water, but you can't make him drink. Trying to get people to actually do the stuff that are, you know, yeah, I'll get around to it. So the idea is getting stuff done. So you should not have joint executives. When you have joint executives, sometimes that creates twice as much work. There should be an executive one and executive two. Why no? Because of his joint executives, they got to do everything together. They got to go to the surrogate's office together. They have to sign the checks together. They have to all go to, sign deeds and contracts and closings. You know, pick one and not joint. Some people, you know, I've had clients say, I feel bad. I got 2 kids. How can I pick one over the other? I go, where are the Elks Club? I go, so that's easy. We wrote down the 2 kids' names and we shuffled it on the bar. And I go, hey, Tom, pick one of these pieces of paper. Another guy at the bar. Okay, George, this is who's going to be, this is one of your daughter that's going to be the first executive. So again, not that complicated. And so, you know, logistically, we prepared a will, we sent it to people, and most people come in and sign. You know, some people said, I'll go to a notary, that's fine. And, but again, they're, you know, going back and forth there, rather than people, I want to make an appointment to sit down. I goes, okay, you got a phone? Yeah. You got an email? I want to make it easier for you. Just, however, Mr. Shaw, Kenneth says, I want to come in and go over. Okay, Mr. Shaw, you're married, right? Yeah. Are you disowning your wife? No. Okay, you got 3 kids. Are you disowning any of your kids or treating them unequal? No, everything's equal. He goes, then why do you need to come in, at least to go over this? You do need to be in front of the humans to sign, but you don't need to come in. Now, even if you have the best will that's ever done and properly signed, many assets go outside the will. So, for example, if you own a house, husband and wife, automatically go, if someone passes, automatically goes to the surviving spouse. If you have 401k, IRA that has a beneficiary, the will can't change that. So we tell everyone, listen, if you gotta make sure, it's a good idea, number one, to get a printout that you can put in with the will envelope that you keep under the bed or in the closet, saying, listen, these are other assets, but this is what kind of I have. Makes it easy for people. There was a man that, again, talking about changing the will. He goes, Kenny, I want to update. I want to have a new will. I originally left everything to my 2 grandkids, but I haven't seen them in 2 years. They didn't even come to my wife, their grandmother's funeral. Okay, fine. Do a new will, properly signs it because he was also sick. Never changed the beneficiaries of his IRA. So unfortunately, these bum grandkids that never visited, they're not talking about people who live in Alaska. You know, they live 2 towns over. They're the one that got, rather than the people that this guy was friends with. You know, so other things. So if the bank account is joint, so whatever, if you have people's names, it goes outside the will. But the will changes other things. So let's see. Now we talked about who's got your stuff. Okay. Let's see. Some people also have what's called specific bequests. So, for example, some of the ladies say, listen, I got 3 kids, I want to treat it equal, but my jewelry, I want to go to my daughter, my granddaughter, because my son, the executor, he's going to bring the cash for gold. He goes, what do you give me for this junk? Let's see, some of the times the guys have stuff that has a little bit of value, is important to them, but if the daughter, he goes, these stupid baseball cards, or I don't know who he's got these autographed up things are. I'm just throwing them out. They're, Joe DiMaggio's autograph might be worth something. I don't know. I used to get autographed Hall of Famer photos for my son as Christmas presents. And my wife goes, your son has no idea. You might have been 12 or 13. He has no idea who these guys are. He goes, he doesn't have to know who they are. But, box the stuff up and brought it down there because it's cluttered in our house. Now, once a year I call my son and I goes, good news. And his response would be, who died? Because it's one of these Hall of Fame guys, because it's worth more, because they can't sign anymore. And some people ask a specific request, say, listen, I'm very active in my church or this charity. I want to leave 10 grand, I want to leave 15 grand. It makes me feel good. Okay, fine. Not a percentage because it drags it out. Now, we also have the reverse specific request. I leave nothing to the bum. Not a dollar, not no reason, nothing to X. Simple enough. When the will is probated, you still got to send them a copy. That's required by the statute. And if they want to spend lots of money challenging it, they can. But they're just like sometimes like someone wants to challenge something. I goes, do you think that spending how much is a stamp now? Like 77 cents. Do you think spending 77 cents will get you any money? Probably not. well then, don't waste a dollar. You know. Now also, we want to have clauses that, you know, we love kids, we love the grandkids, that they don't get the money outright until they're 21 or an older age. Because 19-year-olds do smart things with money. You know, I would go to high school down the road. Geez, if I would have got money when I was 18, I would have been like driving around a rusty car. I would have went to the Maluba because I need a Trans Am, you know, big engine, so I can drive real fast and get tickets. So that's the idea. We don't want, and so if you leave money for grandkids, even great grandkids, sometimes it's better. Listen, they don't get it until they're 21 or even 25, but the monies can be used for college. Let's see, how much is University of Miami now, private school, not a public school, where my son went? One of my college teammates, he got married later in life, he goes, Kenny, you didn't tell me how much the school cost. I goes, well, it's an investment for two reasons. I mean, it's a better school than, you know, going to like Appalachian State, and also you're hoping that the one that you spend all this money for will visit you in the nursing home down the road. Okay, so in a way, that's, you know, that's a little bit. Now, when there's minor children, for some of the people, we have what's called, you know, a testamentary trust. You know, people, I tell people, listen, you got minor kids, we can have a clause in the will that your minor kids, they get some when they're 22, some when they're 25, and the balance when they're 30, but you don't need to spend 6, 7, 10 grand setting up an elaborate trust right now for these people. So the trustee holds the money, and someone's a guardian who kind of watches the kids. Now, one of the things is surrogate, there was a change in the law some years ago. The old way of doing a will, person signs and two witnesses sign, and but then when the person died, one of the witnesses had to sign an affidavit or go to the surrogate's office and sign papers saying, I was a witness. And a lot of times that was difficult because you could find the people when they died. When my grandma passed, we finally located one of the witnesses because it was signed in Vercammen County, and the lady goes, yeah, I used to work in an office, so I can sign the papers. My fee's $500. $500, we're not paying you $500, my dad says, well, good, then you get the other witness. Well, she's dead, yeah. So it would have cost us thousands more. So they changed the law to have what's called a self-proving will. Self-proving will. So the person signs, then there's two witnesses, then there's the attorney and notary, and everything is done twice with certain language that goes in there, so it's self-proving. Surrogate will also say, make sure you have a self-proving will. I had an attorney colleague that I knew his office wasn't doing self-proving wills on purpose, so they would try to get the estate down the road. And one time I said, hey, you guys are going to get in trouble someday for not doing self-proving wills. The law changed. He goes, well, if someone wants to have a self-proving will, we'll do it for them. He goes, no one in Carteret knows what a self-proving will is. And he goes, and here the attorneys don't know what a self-proving will is. You know, so get a self-proving will, and as the surrogate says, don't use a cheap form online, and it should have something that says no bond required. Okay, so let's say some people don't want to give money to a child or grandchild, not because they don't like them, but if they're on Social Security disability, that could disqualify them. So sometimes people set up elaborate special needs trust. Other times someone says, hey, one of my clients, she goes, I love all my 4 kids equally, but my son has an alcohol problem, and if you give an alcoholic $100, he'll buy $100 worth of booze. If you give him $1,000, he'll buy $100 worth of booze, and then give it away to his friends at the Legion or whatever bar he's at. So he goes, this way they had one of the daughters be the trustee for the funds, and that was good because the guy's ex-wife filed a motion in the court to say, oh, Judge, I want you to compel this trustee to pay the alimony I'm owed. And I represent the estate. I goes, no good. That's why you have these kind of clauses that it's the testamentary trust is a spendthrift. It's a sole discretion, and it's protected from even Medicaid and from taxes. So when a few things is protected from taxes and Medicaid, and the judge says that Vercammen's right. That's the law. Okay, so and by the way, some people who are working, they work for corporations and they have what's called legal plans. Some companies, I know Wakefern has MetLife, some of the J&J people have ARAG, other companies have a company, and that pays for the documents, so it doesn't cost people anything. So, people, we get a call once a week. I want to come in and I want to get a trust. My mother used to call me every year. I'd say she's still around, she's 93 years old. I want to come in and get a trust. I'd say, were you watching Susie Orman on TV? She says, yes. She goes, Susie Orman is right. If you live in New York, California, or Florida, where probate costs a minimum of $15,000, it takes a minimum of 3 years, but not New Jersey. And I said, also, Susie Orman sells trusts. So if you move to California, move to Florida, you don't want to have the assets in your name, you set up a trust, but you don't need to spend that money here in New Jersey. Oh, and by the way, typically, most attorneys we charge a consult fee, but if someone comes to, one of our programs and fills out our form, we don't charge them the consult fee. Okay. The last thing I'm going to say on wills is, a will is good forever. Maybe you want to have some changes to it, but if you sign a will at the end of in November, it's good 20 years from now. Let's see, and it's good any other state. Okay, a little different. I'll touch upon powers of attorney. Okay, Guy, you had a question?
Yeah. If you have a will and it was done several years ago, so that it was the two witnesses who signed it, etc., does that still mean you have to find those witnesses, or
depends if it's, the question was if you had a will done, I'll say 5 years ago. If it's a self-proving will, no, it's good basically forever. If it's an old one, non-self-proving will, I was talking to the Edison seniors, and one of the ladies said, mentioned self-proving, is my will self-proving? He goes, I don't know. She goes, you did it. I goes, okay, do you have it with you? No. I goes, okay, come on in, because she was one of my elk brothers. I goes, well, number one, I didn't do it. Number two, it's not a self-proving will. So I said, you should get a new one, because the chances of you and and Tom finding this person that worked in the UAW legal plan office in 1990, everyone's long, they're gone. Are you with me? Yeah. They're gone.
So that means that.
I mean, take out the original will, and was it signed in front of two witnesses and a notary is kind of our rule of thumb. And you got the original, because a lot of the attorneys used to keep the original will. They would say, hey, it's for your safekeeping, and we're very organized. And that goes, yeah, I'm organized also. But the Supreme Court came out with a memo saying, hey, these are property of the clients. The problem was the attorney would die or retire, and someone goes, oh, I need to get my original will. And where the law office was, it's a bakery, or, it's gone. So I remember when the Supreme Court came down with a memo in 2000. Now, I admitted to the bar in 1985. So it came out in 2003, and we had to call and send letters to hundreds of people saying, hey, we got your original will, and you got to make arrangements to pick it up, or get it. Yes, ma'am.
When did self-proving wills start, and can the lawyer and their secretary be the signatures on them?
Yeah. So it was the self-proving statute was, I believe, in the 80s.
Oh, so
but the problem was there were small offices that, like the guys I know in Carteret, it's only the attorney and his one staff person. And, so they
That's
didn't
what I'm
have,
thinking of.
they didn't have the people to do a self-proving will anyway. When I first started, I used to have to, like, my wife was a teacher in Marlboro, we lived in Edison, and I said, oh, after work, can you rush up and be a witness on this document at 6 o'clock? Because we needed another body, or knock it on the door of Pete Moscato and say, hey, Pete, can you and one of your people come over? This is why nowadays we try to schedule it between 10 and 3, because we know we got humans in the office. And also you're not fighting school bus traffic, you know.
But is it good to have that as opposed to a neighbor or friend or something
No,
like that?
anyone as long as they're over 18 and not insane. Because what if it's a self-proving will, you don't need to find the people.
Okay.
Let's say, you know, and I joked that I'm practicing, I was talking to our probate judge on, you know, it was a break between cases, and he was retired on recall. And he goes, Kenny, what about you? And he goes, I'll retire in 24 more years. So, how old are you? He goes, well, I'm 60 plus, but if I'm just doing wills and probate for nice people, it's not work. And then I said to the judge, and if I retired completely, I would drink too much. And I would have no, you know, it was tough during COVID when it's like trying to keep busy. And yes, sir.
What makes probate easy in New Jersey?
Probate is very easy in the state of New Jersey. All the surrogate needs is the original will, a death certificate, a check for about $190. Let's see. Now, a lot of my clients will say, listen, I want you to at least help me out. I mean, you know, the lady's 76 years old, and she's also kind of frail on the family member passing, and the son goes, Kenny, you do some of the stuff, I can do a lot of the legwork, but that's why. But, you know, that's why, you know, there are people that are called trust salesmen, and they'll try to say, oh, probate's the devil, and it takes years. That's not the case in New Jersey. I read a book that was called Building the $1 Million Estate Planning Practice, and the book was really about charging people $5,000, $9,000 on this big trust kit, telling them, oh, that's what you need to do. You know, you always get these letters in the mail from people that will give you free dinner, and it's also a financial advisor trying to bring over their, you know, your assets. But I read the book and I goes, you know, how could would I feel comfortable telling my best man's mom, oh yeah, you should do this like fantasy trust? No, because she kind of lied. Okay, the last thing I want to say on trust is, get your stuff done. You don't need to be a Carl. What's a Carl? Now, Carl is very, very smart and a head engineer. He's a retired engineer. And, you know, he did come in, and I said, listen, you know, I would recommend we do this, this, and this. He goes, I want to read up on this. Carl, you don't need to read up on anything. I went to law school, I passed the bar. I go to seminars. I wrote a book on this stuff. You know, not a self-published book, but a book that the American Bar put out. You know, well, I want to read more. Okay. Carl. 2 years later, Carl's daughter calls. Do we have Carl's will because he died? No, he wanted to read up on stuff. Yeah. These are, you know, these entities, you know, these are like the people that they used to get a new car and they want to read a book from cover, you know, about everything. When I had knee surgery, I didn't even ask the doctor how he was going to do it. I don't want to read about the knee surgery. I go to him whenever I have a new, because I do a lot of running. A new orthopedic thing. I call Rutgers track coach. He goes, hey, who do you have for? And it's whatever part of the body. You know, like, you know, the foot. Then there's one guy for the foot, one guy for the knee, one guy for the hamstring, another guy for the finger. Hey, who do you send your guys to? So, when the doctor goes, yeah, you need knee surgery. Okay. Okay, good. You know, and he goes, the only question I asked him was, you know, you've done this before, right? And he goes, Kenny, I can almost do this in my sleep, but the American Medical Association frowns upon it. So the idea is, you know, and also, if you're getting someone to do it, let's say, you don't want to be their first, and when you want to go to the doctor that, you're my first patient. I don't know why people, aside from my mom's like friends, or my friends, I don't know why anyone would came to me when I was first starting out. I don't know anything. I mean, I would read and learn, but okay. Now let's real quick. I ran into what's called a revocable trust, but probate in Jersey is easy. You don't need to spend all that kind of money. But if you do it, it means you're not owning those assets. It's owned by the revocable trust. Some people say, okay, what can I do in case I gotta go to a nursing home? Okay, well, there's two easy ways of avoiding that. Give away your stuff and stay at a nursing home for 5 years, or spend $12,000 to $15,000 what these guys charge for these elaborate, irrevocable Medicaid trusts. A client's daughter, well, I shouldn't say the client. Daughter brings her mom, and the daughter's home. Mom is very concerned about if she has to go into a nursing home. And I could smell. The daughter's concerned about her inheritance. She's concerned about going to mom going to a nursing home because she'll lose. I goes, and they goes, oh well, go to the daughter. He goes, you can buy this very expensive long-term care insurance. Well, I don't spend any money. Okay, well, again, you give it away or you do these elaborate trust things. Then they go to me, what would I do? I goes, me? I'd say, I'm not doing these things. I goes, I could do it. Well, it goes, I don't want to go to the most expensive nursing home that exists. I don't want my own room. I want where it's clean and nice. Because I worked since I was 13 years old, delivering newspapers and cutting grass and cleaning the toilets at fast food places. That's my money. And I don't want to risk, my kids saying, well, they're all the same. Dad can go into the, that one. Or we can just hire a caretaker to watch out for me. If I'm not sick, I want to go to the most expensive one. And, it costs money, but, there's nice and there's not nice. Who remembers the olden days before cell phones and the internet and GPS and stuff like that? So, I'd say my grandma lived to almost 104, and she had her own place in Jersey City until some kid knocked her down on a bike and broke her hip. And so then she's at they call them assisted livings now. A lot of them, most of them nursing home assisted. So before the internet, I told my wife, hey, listen, I'm doing this 10-mile race in Freehold. Jack's is the next town over. One of my buddies could drop me off to go see my grandma. Why didn't bring the kids down? And probably the last time they could see her grandma, where grandma can stand up and say hello, it's nice to meet you, etc. So I tell you, write it down for my wife on a piece of paper, and she's looking at the Rand McNally map, and pulls into the parking lot of a nursing home and goes there. Hi, I'm here to see Virginia Vercammen. And the person at the this place is horrible. It smells bad. It's run down. It's disgusting. And the person at the desk really didn't care about it. Not here. Oh my God, they lost Ken's grandmother. I just saw her last year. She made us spaghetti. My wife, no, I'm here to see Virginia Vercammen. I'm supposed to meet my husband. 608 Route 9. No, that's down the road. This is Smellyville. So there's nice places and there's ones that ain't so nice. Okay, next, let's talk about powers of attorney, because I only got so much time and then they turn off the lights on me. And I got my colleague Brandon, who's much, much smarter than me in financial advising and stuff like that. Okay, now, your will takes care of your assets if you pass away. But a very, very important document is the power of attorney. What the power of attorney is while you're alive, you're authorizing and giving someone you trust, typically a family member, the ability to pay your bills, have access to your bank accounts, and do things legally for you. every August, we're in a rush to do powers of attorney because these 18, 19-year-old kids are going to college for the first time, and the parents realize I don't have no power over them. You know, so it's important to have. We recommend it be only upon disability. But just because someone's married, they can't legally do stuff. Yeah, there's lots of stuff that we do that is on the slide. If I went into my bank and wanted to cash a check, they'd call the police because they would say, "We've never seen this signature before ever." Because my wife's been signing everything for a decade. But the power of attorney is very good because you do it while you're well, and once it's done, it's done. I'd say, but once a week we get a call from someone, "I need to get power of attorney over mom, dad, husband, my brother." He goes, "You can't get power of attorney over anyone. They have to affirmatively give it to you." So we ask, okay, 2 questions. Can they talk to us over the phone, and can they sign something? If both are not yes and yes, can't do it. Well, then what can we do? You have to go through a very expensive and complicated garnishing proceeding in front of a superior court judge. Takes a couple months, and you could avoid that by having the power of attorney. The power of attorney is either effective right away or only upon disability. We recommend be effective. I'd say so that way it's a durable power of attorney rather than a springy power of attorney. I had a client who was a carpenter. He goes, "Kenny, he goes, I don't understand legal stuff." He goes, "I know how to hammer nails." He goes, "Explain to me in carpenter language." I goes, "Okay, your power of attorney, you picked your son. That means that your son can still owe your money right away after he signs. That's called durable. If it's springing, it only starts if he gets a note from a doctor saying you're disabled. Then he can still owe your money. Knowing that, you trust your son. I trust my son, my wife. Okay, good. They get effective right away. Right? So, it's an important document. Last document. Living Will Advance Directive. Living Will Advance Directive. The will takes care of your assets. Your power of attorney is while you're alive. What the living will is, you're at the end of life, and you're in a coma, irreversible medical condition. You can't get up, you can't talk, and there's machines keeping you alive. What the living will basically is you're giving instructions to hospitals and doctors. Listen, if there's no hope for me, I don't want feeding tubes, respirators, etc. And when they first came out, people were afraid to sign them, saying, "So, if I'm a ShopRite and have a cardiac, they're just going to leave me there and not do anything?" No, the ambulance people always got to do everything, but it's more kind of towards the end, And I remember I used to say, if I couldn't run every day, I want to be put down like they did the racehorses. Now, the first time I was on crutches with the cement boot on me, but it was great. Don't put me down yet. I still got some time, but if I can't open up my eyes, no one's going to be visiting me, where I'm just, so that's why it's important to have. After it's signed, you want to give a copy to to the family and to your primary doctor. So, in a nutshell, that's kind of what you need to know. So, so 2 things. I'd say if you don't have a will, get one done and get a power of attorney living. If you have one, take it out, because sometimes it goes, does it still contain what you want? And can the executor still do that job? And sometimes when we're doing the wills, I say, listen, I don't mean to insult anyone, but I don't think that you should have this person as your executor. And it's the husband or the wife. I goes, of course, our rule of thumb is, can they drive to the bank and can they walk up a flight of steps? And can they do the job? It's not that we're anti-senior citizen, we got to be practical. If someone is blind and can't see, they can't drive. But also, it's probably best if you get someone else to do it.
Is it okay to have somebody as an executor or executrix as if they're in the will?
Oh, that's the commonest thing.
Yeah.
I mean, usually whoever, you know, the person, sometimes someone goes, I want this person as the executor, and they have grown kids. He goes, why are you having the kids? Is there something wrong? Well, I think it's very complicated. This person's my accountant. He goes, listen, it's not that complicated, you know, to do it.
Is the living will the same as a DNR, the hospital?
Well, typically, the living will, you're also picking someone as your medical proxy that has the legal authority to talk to doctors and get. I mean, we put in our living will the do not resuscitate form. You know, and there's no perfect document, but you know they look to see. Okay, what's the person's health, age, etc., and the likelihood of some kind of recovery. And the other important reason for having a living will is we've also had examples where one child was the one that was always helping out and was taking mom or dad to the doctor's office. And then there was someone else that did nothing except show Thanksgiving with an appetite. But then it's like the person's in the hospital, and at the end, that person comes and goes, okay, listen, I'm in charge now because I'm the oldest and this is what we're going to do. And the answer is no, you're not in charge of anything. It's what was in the document that was signed, and you're lucky we even let you into the room because you weren't around to help out when you were needed. Okay? All right. Last question, then I'll take some questions afterwards, because I don't want to. Go ahead.
What do you do if you don't have any family to take those positions?
Well, then you don't have anyone. Then the doctors the doctor said, we will do what is medically appropriate under the circumstance.
If you
And
have a
because,
living will, though, they have to abide by it.
well, they'll also look to see what's the person's age. If someone had a heart attack and they're 45 years old, and their family goes, don't do anything. Goes, wait, this person's going to be released in a week. You know, okay. And that question was asked to me. There was this little old lady that I did her will, and I was the executor because she didn't have kids, and her husband had died, and she had a power. She didn't want to do the living will. Then all of a sudden, the hospital. She's in a hospital. I go there, and I goes, do you want us to remove life support? He goes, geez, doctor, I feel bad. I wish the person would have had the living will so I didn't have to make that call. And he goes, yeah, now you know the right thing is for someone who's 92 years old, it's not going to open up their eyes and get out of bed. But you hate, you kind of feel bad to say, yeah, you do it now. So the doctor goes, we will do what's medically appropriate, which was remove that. Now, I'm going to stay around afterwards and answer some. Brandon, come up. Brandon, where do you work and what do you do for a living?
Yeah, so I am a vice president.